that we were on a base level at least meeting 75% of the criteria. We were compliant in providing the availability of specialized court divisions, which was one of the identified international criteria. We were also compliant in providing small claims court with simplified procedures, because that is something that is done in our summary courts, and we do have guides for that for the individual litigant. We do have a mechanism whereby cases are assigned to the judiciary, which was one of these very specific measures to meet under this criteria. And the only criteria under this major heading, which we believed we were not quite meeting as yet, was the non-compliance to date on pretrial attachment. The second major criteria that the World Bank recommended for international courts and their intentions to improve their services, improve their processes, was for case management. In our assessment, generally we believed that we were 60% compliant in this area, insofar as we had, excuse me, so I'll just be to find my notes. Insofar as we had adopted a case management system, an electronic case management system in the 1990s, and this was a basic recommendation. We are now trying to upgrade that system. The report also spoke about pretrial conferences by the judges, and that is something that has been in practice for many years. What continues to be done by the judiciary is to continue to massage those rules and to update those rules. And most recently, under the Criminal Procedure Code case management rules, this was done by late last year. So new rules are now in place for case management. Although not, in addition to that, the only non-compliant area that we felt under this major heading was providing a comprehensive modern court performance management tool to bolster our existing manual mechanisms. And this goes without saying, Member Mr. Austin, that given the volume of cases that is passing through the courts, our reporting is limited at this time because we have a 20-year-old system. We do develop basic statistics that is used by the court. I know the Auditor General said it is not used, but that is not agreed by the judiciary nor the Chief Justice, who is responsible for steering the way cases are managed through the courts. We do acknowledge that there is a need to develop and improve our performance measurement tools, and that through the improved technological system we would be able to do so. I read the ICC report, and there were some of the targets listed in the report, speaking about times in which trials were going to, cases were, crave your indulgence, on-time case processing, duration of pretrial custody, case file integrity, etc. With respect to some of these, I do agree, and I think the Chief Justice would agree, that any new system could be modified and customized to give better data to the courts to manage these processes. However, the data itself can only be used in looking at the whole of the issues that are before the court system and not just judicial administration. I believe that the Auditor General has adequately put in her report a recognition of the, for example, of the small defense bar that exists in the Cayman Islands. Whilst it is mentioned in the report and raised as a concern, what was not explored in the report in any detail is the true impact of that small pool of persons against the cases that are before the court every day. Furthermore, on other areas of compliance in the World Bank report, one of the options or the recommendations was to introduce alternative dispute resolution in court systems. They mentioned arbitration as a method in which judicial systems can use to expedite cases and to get cases moving. The Cayman Islands in 2012 introduced and put into effect the arbitration law. So therefore, individuals are free to use the processes under that law to more swiftly expedite their cases or resolve their cases. The other option is mediation rules, mediation of cases. And for those who attend the Grand Court openings, you will note that from 2016, mediation rules were developed by the Grand Court rules to introduce mediation in family cases because there was a significant concern by the judiciary of the length of time these cases were taken to resolve. This system has commenced because of the limited staffing, the limited number of judges, etc. It took a while to get off the ground, but cases were being expedited before they were getting to court and resolved before they were getting to court. The Chief Justice has tried to focus on this area, and we are trying to create and develop an actual dedicated unit so that all of our family cases, whether in the summary court or in the Grand Court, go through a mediation process before they are heard by a judge or magistrate. And it is also the intention of that court to expand it to civil cases that come through the court. The profession, the bar, have been met with. They are aware of this is going to be an expansive area for the court and the judiciary to resolve cases quickly, to resolve cases more affordably, because if they are not being heard by the judiciary, then it is an opportunity for litigants to not have to spend so much money trying to resolve their court matters. So there is a consultant who has been hired by the Chief Justice who is very experienced in mediation in the Florida courts. She has agreed to lend her services, and she is working with that unit right now to develop in a very comprehensive way a robust mediation program that runs parallel to our judicial program. As regards the ICC criteria, I think I indicated that I have no objection to taking on board the recommendations of that report and as complementary to the work that has already been done by the judiciary and at the judicial administration to improve the judicial processes. But this will not be realized in any full way until we are able to complete our technology initiative and to introduce our new program, along with other IT measures that must come in place alongside that to expedite cases before the court.
Thank you, Mr. Chairman. Just a point for clarification, if I may. When we undertake our audits, we go to great lengths to agree facts with our clients. And so hearing in the early part that the Chief Justice and the Court Administrator didn't agree with findings in the report alarms me enormously. So I would just like to clarify, or maybe I misinterpreted what was said, but I thought I heard that you didn't agree. With regard to the performance measurement and the performance management system, what precisely do you and the Chief Justice not agree with? Because if there are errors, factual errors in our report, then I'd want those corrected. Thank you.
Thank you, Mr. Chairman. The concern of the judicial administration and the judiciary is not so much that you have made recommendations via the use of the ICCE report, but the lack of attention paid to the work that the court was doing using another mechanism to measure and to introduce efficiencies in the court. There was merely a mention of it in the court. There was no attention paid to the criteria set out in that report or any of the activities that were done by the court over time to develop good practices within the court that are recognized by the World Bank for courts to improve services and increase efficiency. That is the concern of the Chief Justice and the Judicial Administration at this time. But
your position is that the Justice Administration believes that the World Bank is a better standard than the two standards that were used.
No, it is no, sir, Mr. Chairman. We believe it is a standard that is recognizable and should have paid due attention to at the time of framing the report. Not that one is better than the other. What I note the ICC does is gives more comprehensive information on how courts can improve. But a lot of this is going to be dependent on technology. I reviewed the report. I looked at the members of the ICC. And I'm also aware, as somebody involved in court administration, what a number of our counterparts are doing and the activities that they're undertaking and the investments that their governments are making to help them be more efficient. And we are not there, but that is a dialogue we will continue to have amongst ourselves and engage the government accordingly as we progress. But the suggestion in the report is that the court has done nothing at all, and that is not accepted.
I don't think that that is a fair assessment of the report. That may be your assessment and the judicial administration of the view. That is not the view of the P.A.C. committee, nor the Auditor General. There's nowhere in this report that it says nothing is being done, right?
It says that there are no performance measures. There's no activity to help develop performance measures or standards. Whilst I will agree that the actual refinement of the data to the best that it can be used does not exist. I agree with that. But the suggestion that we do not use our statistics at all is not looked at. I am not sure where the Auditor General is getting her information from in that regards. And the Chief Justice does not agree with that.
Would suggest that that information came from the courts and the court records, but I'll let the Auditor General speak for herself.
Yeah, yes, we say it's limited, the information. We go by the evidence that was provided by the witnesses. So we saw limited evidence of performance information. If we'd have seen significant information relating to the World Bank standards, which we do reference, then we would have given credit. So our position is we've tried to be fair based on the evidence we've been given, and the evidence we've seen around performance is limited. But we don't say there's none there, absolutely not.
Just along on that line, Mr. Chairman, through you to the witness.
You could just guide the witness a little bit, please. Answer the questions that you're asked. Don't take the opportunity to go to, because you're going to be questioned on each recommendation. We don't like the idea when you try to summarize all of the recommendations on one answer. So let's try and stick to the specific questions that are being asked.
Thank you, Mr. Chairman. Through you, in addition to improved technology, to improve case management, the Auditor General's report also noted the absence of clearly defined standards of performance measurement, particularly used for assessing both the timeliness and quality of cases progressing through the summary courts. It went on to mention on page 13, the first paragraph, top of the page, last sentence, that it is not possible to identify what is working well or where performances could be improved. In your previous answer, you mentioned both improvements in the computer system that is being utilized by the courts, as well as other measures to improve case management, presumably through procedure. I wonder if you, Mr. Chairman, through you, the witness could advise this committee when the planned completion of both the improved technology as well as court procedures is expected to be completed.
Thank you, Mr. Harris. The court procedures updated rules were completed last year, October. They are now in force and they are now being applied by the court to speed up trials, to provide tight timelines to defense counsel, prosecution, and the defendants in progressing their matters through the court. What cannot happen at this time, even with these rules, is to introduce these measurement tools in our current IT system, because the IT system is a DOS program. It is no longer supported, so therefore these measures will now have to be introduced in our new system in order to collect that data and to run reports on those kinds of activities.
Thank you, Mr. Chairman. Before getting into my first question, I just want to take a time out to read Section 87 of the Cayman Islands Constitution, Order 2009, which says, "There shall be a Public Accounts Committee of the Legislative Assembly with power and responsibility to examine the public accounts of the Cayman Islands and the accounts and financial dealings of all authorities, offices and departments of government, of all courts, and all government-owned companies." Just to expand, Mr. Chairman, on your opening remarks, and I think it's important for the listening public to recognize that what we're concerned with here today is the roughly just over $15 million that was approved for the court budget in 2018, and the $5 million that was spent in terms of the administration of the court. It is more along those lines in terms of the value for money and efficiency that we're looking at. And I just want to have the listening public to reinforce that this is not an issue with regards to the judiciary or the cases before them or anything, but rather the efficiency of the court system within our democratic process. It is an independent body. It plays a very important role in our democracy. And it is very important for us as members and witnesses to reinforce to the public that at the end of the day, we don't do anything to undermine the judiciary at any point. I just want to make that clear that this is just based on performance, efficiency, and what we can do to improve performance. What triggered this audit came about as a result of the government's purchase of the Scotiabank building. I think it was maybe 10 million or something like that, if my memory serves me correct. And the witness may recall that this month, exactly this month, 2 years ago, the witness came before the Public Accounts Committee, and I think the exact words were speaking about the dire situation with regards to the lack of facilities within the court that needed to be dealt with. And I think based on that, and from what I understand is that recognizing that there was a dire need for more space and everything, that the government went out and purchased the building. And what it is that we were, I guess, a little bit surprised about is that when you spend $10 million and there's no business case, and roughly 2 years later we are here, and there's still no business case to justify that expenditure, then naturally the question is then, what information is being used to make an informed decision before we're basically spending public money? And that is where it is that we're trying to get to in terms of the whole performance management of the court system itself, and not with regards to the judges, the judgments, or anything like that, but just efficiency. Because at the end of the day, one of the things, one of the reports I also read prior to coming here today was actually the report from the Office of the DPP, from the Director of Public Prosecution, their annual report in terms of the amount of cases they had, the disposals, and everything else. And one of the things I also looked at was the Economic and Statistics Office report. And what really surprised me is that between the ESO report, the DPP report, and even the Auditor General's report, some numbers just wasn't seeming to reconcile. So I'm kind of left wondering what information, or where is the source of the information coming from. I mean, a case in point, just to expand on that point, is even the annual HR report that is done by the portfolio of the Civil Service, where the very staff count at the end of December 2018 is different from what is inside the Auditor General report. So I am begged now, as a representative of the people who vote for money, what information exactly is being used to make these decisions when some of these information do not reconcile. And we do understand that there is a very old system, a very old DOS system. The only good thing I can say about having a system like that is that it's very hard to hack, because most of these hackers would have to go back and learn the language from back there. So there are advantages to the system. I mean, we already saw that the police lost almost 1.9 terabytes of information that they can't find. At least we don't have to worry about that in the court system based on the system that they're using. So there are advantages to it. So the whole idea here, just to collapse everything that I'm saying, is for us to look at the efficiency of the court system, because ultimately within our democracy, I mean, judgments and everything else has to be timely, and if there's not space and there's not courtrooms, to borrow from Martin Luther King, justice delayed is justice denied, we need to ensure that we do have a court system that is there to meet the needs of the public. Now, granted that, some of the systems are old and everything else, what I'm hoping to get from this hearing today, and for the government members that are also present, is for everyone to sit back and say, wait a minute, this is what we need to do, this is where we need to spend to get the court system operating efficiency within our democracy, because it is a very important role within our democracy. And that is really and truly the purpose of the audit today. Now, I know as with most reports, it is critical of what it is that people do, and naturally people can become defensive, but I say what I say in the light that the purpose here isn't to pick a fight with the judiciary, and that is not our intention here, but rather to see what needs to be done to make it more efficient and serve the public better, and that's ultimately what we are all here for today. So I just wanted to put that out there so the public and everyone don't look at this as this being a situation between the Legislative Assembly and the judiciary. The Constitution is clear with regards to our role, and ultimately if we are voting public funds to the judiciary, then we need to understand what those funds are being used for as opposed to being used for something else. If we're not spending enough on the judiciary, then I'm hoping the witness can make that clear to us so we can go back and do what needs to be done to make sure that we have an efficient judiciary to serve the people of the Cayman Islands. And that is ultimately the purpose here today. And I want to say that to put out there. So with that said, Mr. Chairman, what I would like to understand from the witness is, from a performance evaluation standpoint, what is it or what is being done for them to say that the court is efficient, here's what we need to improve it, or what is it that we don't do? No, we do understand that in some cases, the court administration is also at the mercy of the DPP, because when it comes on to criminal matters, this is something that's brought by a separate department, and they have their own space, they have their own time, and they have their own methods and everything else, and no one can tell the DPP what to do also. So that's also another separate entity that is separate from us as legislators, that we have no control over other than to make sure that we vote the funds for the DPP to do their job. So, and we also recognize the police plays an important role as with the Department of Community Rehabilitation. So there are a lot of moving parts here where everything converges within the court. Then there are also civil issues. So the main thing that we're trying to get here today, which I'm hoping to come away from, is what do we need to do to make the court system more better? So the first question through you, Mr. Chairman, to the witness, and I apologize for the long preamble, is what, in our opinion, do she believe that needs to be done to get the court to the standard that they would like to see? In other words, what does success look like for the court administrator and the Chief Justice, and then what do we need to do to achieve that success? Thank you.
Thank you, Mr. Saunders. I think I would start off by saying that the court recognizes that success is always a work in progress, and that there are things that we work on and we try to achieve diligently, and there are always going to be things that we are always working on. With respect to how we get to a point of success, it is not one single thing, it is multifaceted. The urgency or the priority of new court facilities has been the request of the Chief Justice as far back as 1999. So at least on the record, we know that the need for additional facilities to meet our court demands has been going on since 1999. At that time, it was identified possibly 3 years from that they might get new facilities. And this is outlined, just for the record, in the judiciary's annual report of 1999-2000. We find ourselves in 2020, and I would state that, and I agree that in August of 2018, as part of the outline business case, the government did purchase the Scotia building for the courts. It is important to understand the context of why the government felt that was necessary at the time. And the context is that from 2015, there was another renewed effort to ascertain what court facilities were needed, and that was led through the Ministry of Lands at the time, along with the Judicial Administration. And an outline business case was being engaged with a view of creating court facilities that would take the country through a 25-year period. When that exercise was complete in 2016 and the financial data became available, it became clear to all concerned, including the Chief Justice, that that was simply unaffordable. And the matter was brought before the caucus at the time in 2016 to show them what the options analysis revealed, and the range of costs for new court facilities. And the government, unsurprisingly at that time, made it very clear that that was unaffordable. So, in effect, the OBC was stalled. Because judicial administration has a very personal vested interest in ensuring that project does not go on the back burner, it was agreed by the government for the administration to work with the OBC team to reframe the objects of the OBC and to look at alternatives. And the first options really was about where to put the court building, the size of it for over a 25-year period, to live a 25-year period, and whether it was a greenfield site outside of town or whether it was a complete restructuring in town. And those were the sort of options that were available. And they all exceeded over $100 million. The permission was given to go back and revisit. And at that time, there was no identified property or land in which the court or anybody could say, well, this is what the government is going, this is where you can build the courts. The earliest exercise in 2015 from the stakeholders, as I am advised by the OBC team, actually concluded that the major stakeholders preferred for the courts to stay in town because that's where their businesses were and that's where we felt most comfortable to access the services. At that time, the cases, of course, the status quo continued, and a decision was made to purchase a building that was adjacent to the courthouse to allow for the court to transition out of Kirk House, which is our second building that is not owned by the government and that has already been deemed not fit for purpose, and to modify the new infrastructure proposal to include the entire block, namely the Scotia building, the Celebration Park area, and the main court building. And that is something that is the subject of the current OBC. Because the building was purchased and it was meant to accommodate the long-term needs of the courts, based upon the Chief Justice's recommendations, he asked that temporary court be put into the building until the new plan is agreed by the government, and also that a permanent home for the Court of Appeal be put in the building. And these have now also again modified the outline business case, because this is something that is not needed just for the new court facilities in the long term. There is a urgent need that is being to be satisfied, whilst the more long-term proposal is being crystallized and agreed by the government. So this additional modification of the OBC scope is also what has caused some level of delay. And they took most of 2019 working out these changes, cost analysis, et cetera, because the original purpose of Scotia Building was mainly to be accommodation for the staff, the accommodation center for all of the staff, moving most of them out of the main court building and moving most of them out of Kirk House and phasing that building out. Where we are trying to realize the immediate request to actually renovate Kirk House, Scotia Building, to accommodate the temporary Grand Court so that criminal cases could be heard there, so that we can increase the number of criminal cases that are running at one time, and to also put in a place for the Court of Appeal, because as the Auditor General report notes, the Court of Appeal, when they arrive, they displace the other courts, including the Grand Court, and in particular the Summary Court. And what we are finding is that the number of sessions or sittings the Court of Appeal is having is actually beginning to increase. So by them not having an actual dedicated court or a home, then there is going to become a higher likelihood that there will continue to be more displacements of the Grand Courts and the Summary Court. The agreement of the master plan is a priority, and we continue to work with the Special Projects Department and the OBC team to complete that, to bring the final information to the caucus. They have been presented with high design plans, and Cabinet have been presented with high design plans already of what that should look like. So this is not a surprise. Whatever we provide to them will not be the first time they're seeing it. They are aware of what the big proposal is, and they're aware of the projected costs for it. The other side of things is staffing. I believe that the report spoke about that the staff of the judicial administration for quite a while was about 60. We have increased it. However, we have had to rely on temporary staff to help to alleviate some of the pressures that the organization is facing. In accordance with the budget requirements, I have asked for more staff, and I am thankful that I have gotten the funding for the posts, and I'm working with our HR manager to fill those posts. And whilst I don't mean to speak out of turn, because I know the government has to play a very fine balancing act when allocating budget. As a chief officer and the court administrator, whilst I was very pleased in November when budget was approved that I actually got the posts that I asked for, and that I actually had to lobby for, quite frankly, to ensure that there were no cuts to my budget, particularly on HR. I find myself now, with the increase of the cost of living adjustment, or whatever it's called, to now find the money in my existing budget to pay for that, because there was no specific budget allocation for that. Now, when I approach my technical staff, they tell me cut posts that are not filled. I can't do that. So we are still working through this year exactly how and what efficiencies we can bring into how we do our work to keep the costs down so that we can pay the staff the additional funds whilst I'm still able to successfully stagger or fill the posts over time. Workforce planning is something that has been raised by the Auditor General, and I am in full support of that. And that is something that I will be working with the Chief HR person who is with me to do, along with cross-training of staff, because the work of the court changes. No longer do we live in an environment whereby a person does one job or one thing. You go where you are needed and be flexible in your skills, and also talent development. So those are the HR aspects that we are trying to develop the staff so that in terms of competence, they can deliver the quality of services the courts needs. And this is what we partially see as success. In terms of our IT technology, and what we see as success is to finish the court technology program. Our aim is to, across the board, eventually bring in electronic filing of cases. And this is something that the priority identified to me to start is in the Financial Services Division and to pilot that scheme. We also wish to bring in more court recordings because there is a demand of the court for the records of the court in courts where we don't currently have records. And also too, many of our courts of records do not have court reporting services, and that is an area of priority to ensure that our business can function properly. I have been asked by the Chief Justice also to look at
Mr. Chairman,
sorry.
Oh,
I defer to you, sir. So I have been asked by the Chief Justice to expand what is currently our internal paperless initiative and to start looking at options whereby the court becomes almost a paperless court, and we are not dealing with paper files. That files are centralized, they are in one place, can be accessed by all parties from end to end from the beginning. We do have resources or persons with experience with these types of systems that work with our courts, and so certainly that is something that is high on the agenda, but I cannot say that it is part of our current year's planning because it is a new initiative that the Chief Justice would like to do. One of the things that in our database though, and I just wish to stress this, is that we did not enter this activity in isolation. Before we started, we met with the government to find out what resources or support they can give us as we journey through this, this creation of this new product. And one of the things that was raised was the ability to be interconnected with other government databases, because we were very sensitive to the fact that judicial administration acts as a hub of information for the RCIPS, for the probation department, DCFS, whereby currently there are special permissions given to very specific staff members to access the court information to support them in their work, because their own systems, they do not have their own systems to generate their own information. So in building our database, it is supposed to be web-based, it is supposed to be Microsoft-based, and it is supposed to be able to connect with other types of databases, whereby if there needs to be a linkage to transport data, one of the things that we are keen to do, for example, is that if we have to give the disposals to the police of sentences, that information should be able to go from our system to their system. believe at the time the police had already purchased their system or developed their system. But those were the kinds of discussions that we had with e-government at the time. And we are keenly aware of the questions raised about the traffic system that we have in the justice system, in the courts, by the police, in the law, and that too will require some form of improved technology, and we believe that will be able to be linked to the court system whenever that initiative comes to life.
Mr. Chairman, sorry, through you, just along these lines of delays and otherwise, and I wonder if I could focus specifically on aspects of the Office of the Auditor General's report. Paragraphs 28 to 34, found on pages 13 to 16, state that one of the most frustrating aspects of court performance that was raised during the audit was the number of times cases are adjourned. Paragraph 31, found on page 14, reports that none of the IT systems used across the criminal justice system is able to provide data easily on the number of cases that are adjourned or the reasons for the adjournment. That said, some reasons were in fact identified for the number of adjournments found on page 15, paragraph 33, where it states the most common reason for adjournments was that the defense attorney was unavailable or unprepared. I have two questions for the witness, Mr. Chairman, through you. The first is, how does the court manage the practice of adjournments in the absence of proper technology? And secondly, are there court rules surrounding adequately prepared attorneys? And are there any specific penalties for those attorneys or officers of the court who would otherwise waste the court's time? Thank you, Mr. Chairman.
Thank you, Mr. Harris. The court IT system does not track the reasons for adjournment as at this time. The system was not developed to do that, and there's no way for us at this point in time to modify it to do that. The only way it's tracked is by the fact that the magistrates themselves are responsible for the files and the date in which the person is to come back, and is at their discretion as to whether or not they permit the adjournment or not. So it is through judicial persuasion or judicial pressure that cases progress. And the information regarding the few reasons that were given, one being the defense attorney being unavailable, from my understanding of the judiciary and their reporting to myself and the Chief Justice, this is perhaps one of the most frustrating things for them also. They would book trials, and it would be done for months, and then when it comes time for the trial, the attorney is not available, not because they do not wish to be there or they forget the date. It is simply because, for other reasons, there is a conflict and their case has been called in the Grand Court, and that court is a higher court, and it requires them to give priority to that court. In the Grand Court, why do these things happen on short notice? There are a variety of reasons. And it's highly driven by, it could be the defendant. There's no ability in our law to force the defendant to plead guilty earlier. I do believe in the current rules, there are rules now that the defendant should give an early indication of plea if they're going to change their plea. But really, there is no true penalty except in the sentencing stage if a defendant pleads late. So there's nothing that the court can do before sentencing to address the fact that a defendant has pled late and they have technically wasted court time.
Mr. Chairman, through you, the question specifically was not about the defendant perhaps wasting the court's time, but are there any specific penalties outside of conflicts of an attorney having to serve in a higher court? Are there any specific penalties for attorneys who, according to the Auditor General's report, 14% of the time the reasons for adjournments is that attorneys themselves are either absent or unprepared? Does the court afford any penalties for those attorneys who would otherwise waste the court's time?
Thank you, Mr. Harris. With regard to absence in the summary court, I do believe I have given a reason as to why some attorneys find themselves absent.
Yes, ma'am. Which I stated, outside of having to attend a higher court, i.e. Grand Court, in summary court itself, are there penalties outside of having to go to a higher court? And we understand there are a myriad of reasons, but are there any penalties for absence or being unprepared?
With respect to being unprepared, it is highly dependent. Where you would find the most oversight is in legal aid cases. There is an improved tracking in legal aid because we tax bills, they will present bills, and they are taxed. And the court will look at, the taxing officer will look at the amount of time that they say they are attending court, the amount of time it's taking for them to prepare, and give reasonable judgment on the amount of time it should be. To that extent, there may be what you would call a penalty. I'm not sure if that's really a penalty, but it's certainly a review of the activity of the attorney. The court, for anything on a disciplinary level to happen, the only persons who can bring that would be either the defendant who believes that he is not being represented properly, or the magistrate or judge his or herself. And those are the only two persons within that could technically make a formal complaint about attorney conduct. The new criminal procedure rules for both the Grand Court and the Summary Court are meant to put on more strict timelines and more strict accountability on the profession, the attorneys at the bar, to have themselves ready, particularly when it's time for trial. So they have the use of the case, the pre-trial conferences are really meant to make sure that everything is ready and that there is a minimal chance of the trial being vacated and that the judge has the ability to monitor the case. Sorry.
Mr. Chairman, sorry, and I just want to, for everyone's clarification, we're getting deep into lawyer, defendants, and those kind of issues. And I just want to caution this committee that it is an area I'm uncomfortable with. I mean, ultimately, the lawyer, the defendants, and what goes on inside the court is something completely different. And what we're looking for here is the efficiency within the very court system itself in terms of the booking of the court, the use of the court, and everything else. So I think it's important for us to stay within that vein. What I can say from listening to the witness, and one of the things that I myself admit that I am very tempted, but you have to have exercise some restraint, is on the whole issue of legal aid. Because one of the things that really puzzles me, or should I say rub me the wrong way, is that when I look at the disposal rate or arbitration type rate or whatever rate it is, the term that they use, in a lot of the developed countries, more than 90% of issues don't even go to the courts. And I believe, and this is just my personal belief, and I guess as a politician I can speak like this, I know you can't as a witness, but there is a culture within the legal fraternity to milk clients as much as they can. I mean, dragging stuff into court, getting more fees and everything else. And that's a culture that has to be dealt with separately. I mean, because some of these cases that I see that go to court, that type of court, when the person is guilty I know the lawyer could have said to the person, you're guilty, plead it out, and do something, but whatever it is, whatever reason, they drag it to the court system, and then some things happen. Now, that's a different issue for a different time, and that is something that we can deal with at a political stage and in a different venue. But within the ambit of this committee, we were just looking for value for money in terms of the actual operations of the court, the courtroom, and the court space. I think we just need to make sure that we confine this discussion today on that, because the other issues are more dealt with at the full legislative assembly mode and within the political mode in terms of dealing with that culture, in terms of lawyers, their behaviors, and what it is that they do. With that said, one of the things I wanted to touch on was going back to the grand scheme of the building. And I remember hearing the figure of over 100 million for the new courthouse, and I remember saying to myself back then, there's no way the government is going to, after spending 70 million or so to build a go-up building, which is housing close to 1,000 people, to spend that kind of money on a courthouse that is going to be doing 60, 70 staff. I know that wasn't going to happen. So for us, and this going back to my original question, is in terms of recognizing maybe over a period of maybe 10, 15 years, we may spend 100 million, but phase 1, phase 2, phase 3, in terms of the immediate need right now and the medium-term need, what needs to be done for us to have the court system, because we recognize that this is what the culture is, and if the lawyers don't change their behaviors, then we're going to need the courtrooms. So then the question is, what do we need to do to ensure that the administration of the court system works as it should based on the culture that we have? Because none of us inside there can tell the lawyers, well, don't take your clients to court, even though other countries have evolved to that and so forth. So that is really where I think we need to kind of stick on and not get into the actual courtroom. That's it. Thank you. So that's really the question. Thank you.
Thank you, Mr. Saunders. Judicial administration recognizes that whatever discussion we have with the government to actually get court facilities now, whether it's in the next 5 years, that this is not going to meet the long-term needs, because the decision-making is not really based on need exclusively. It is based on need and available monies. So therefore, a phased approach is something that would be, in our view, a sensible approach, because it's simply, if the money is not there, it cannot happen. But what we do not think can continue is the status quo. So something has to be done, and it has to be done in an affordable way. And I apologize, I forgot the actual specific question beyond the phased approach.
The question I was asking for is, what, in your opinion, and the Chief Justice ultimately for him to do his job effectively and efficiently, what do you see in terms of the short and the medium term that needs to be done? And I will start by one simple question, or one simple way to guide the answer is, first, how many courtrooms do we have? Secondly, how many cases are we looking at per year? And then thirdly, what is the average length of each case? Because, I looking at the numbers, the stats, even though they're maybe a bit off, when I look at the number of thousands of cases, I think it may have about 5 or probably less than 10 courtrooms. I even look at the average time, even it takes one person to go in the dock for a judge to read out this and all that kind of stuff. And you do a quick calculations, you'll recognize that there is insufficient courtroom based on the stats. And now, what I can say is that when I look at stuff like traffic, that is tying up the court time. There's some, and I know you had mentioned it earlier in your opening statement, in terms of the arbitration and some of the stuff that can be done. But when I see traffic offenses being tied up within a court system, you're speeding, you get caught, no, unless you're disputing it or something, no. At that point, it can't be where you're disputing it, and the fee remains the same. At that point, if you want to go to court to dispute that speeding ticket, you're talking about 10 times the fine or whatever, so people can at least realize, you know what, I'm not going to drag this thing out. And in some cases, in most cases, I've found that sometimes people just forget to have paid. And I believe at that point, it should be a situation where a penalty automatically goes on as opposed to tying up the court. So there are some parts of it that within the government I think can be dealt with. And since the government is the one who is ultimately bringing the cases, in some cases, those are the kind of stuff that can be sorted out. But no one wants to go up inside the judge, go through the court, waste half a day waiting on a name to be called. No one wants that. So the question is, in terms of, going back again to the number of courtrooms, the number of cases, the average time, but then what can we take out of the courtroom, going back to your earlier point of arbitration, to directly have less demand on court space? Thanks.
Mr. Chairman, just going on to what Mr. Saunders, I want to get this in. We as MLAs or MPs, we get representation from people. A lot of people's lives have been held in limbo because of waiting. I brought it up here in Parliament, one particular case, and we keep saying, we don't get into no judicial decisions. When I brought it up, someone from the DPP said to me, when you asked a question about the 3-year-old that was molested, it stood there for 3 years until everybody's memories had been slighted, then the case eventually got thrown out. Their thing to me was, there was no court rooms, the time, all these things that were not allowing for this case to get there early enough. Of course, everybody's trying to pass the buck. And this is, I think, Mr. Saunders is trying to get to is, what is it, going through all those stats that he read, what is it you all need to be more effective that these type of things will stop happening, people's lives can go on, bap, and get the case on with?
Sir, before the witness answer, I will say, first of all, don't answer that one, because that's a political type question. And I can tell you, if you take the DPP 3 years to get a child molestation case to the court, the DPP needs to be fired. Anyway, thank you.
Thank you, Mr. Chairman. Through you to the court administrator. Going back to adjournment of cases, are there any plans to develop a system that can track adjournments? Is the new IT system able to accommodate tracking of adjournments?
Thank you, members. The new IT system is going through its final stages of customization, and based upon the recommendations of the Auditor General's report, we will be paying very keen attention to the various data that we could draw from the system, and also to create reports to help inform court decisions and administrative decisions moving forward. And under the new rules, only in the Grand Court at this time do we have a case progression officer. And this is tied in with the new case management rules for Grand Court matters. There are intentions to bring a system for case progression in the summary court, but the administration continues to be in dialogue with the magistracy and the Chief Justice about what that will look like, because that court functions very differently from the Grand Court. It is not an area that administration can make changes without consultation, and certainly without the buy-in of the stakeholder who will manage this process from a judicial standpoint. The administration provides a supportive role in that respect, and we continue to discuss with the magistracy how they would see case progression looking like moving forward in the summary court. And that is still being discussed between the magistrates, myself, and the Chief Justice and his delegated judge, who's in charge of the criminal division. With respect...
Don't interrupt, but
sorry.
you need to answer Mr. Chris's question about the number of courts.
I have the list, thank you. And if I miss an area, please do remind me. I have tried to make the notes as best as possible. With respect to traffic, This issue was raised at Finance Committee, and I did take note of the recommendation, I believe, by Mr. Arden McLean, the leader of the opposition, and a few other opposition members, that an interagency committee be set up to revisit the entire traffic law system and the way that traffic is processed and dealt with in the whole justice system. That has been relayed to the Chief Justice, Honorable Chief Justice, and he's fully on board with something like that, and he's happy to lead that initiative. I make note in the Auditor General's report of page 20, which actually sets out the traffic ticket process, and I did note that 7 out of the 13 processes are this is very feedback, pre-court processes, and so certainly there is an impetus and there is a genuine need, quite frankly, to almost transform and modernize the way we deal with traffic in our jurisdiction, particularly when I note that there is now a special unit once again set up by the police to deal with traffic, and that transportation issues continue to be something that is a concern for the police. On the question of the number of courtrooms we have now and what we need, right now we have 7 open courts, and those are used by all of our courts. Summary, Grand Court, Criminal, Financial Services, Civil, and the Court of Appeal. So that is what we have now. The scaled down plan will only provide 10 new courts, and that will mean 10 new courts plus the 2 in the main court building that will remain, and then the home for the Court of Appeal in Scotiabank, Old Scotiabank. So that will be 13 courts that will become available if this proposal from the OBC goes through. It is a big project, and the way that I see the government projects move, I probably wouldn't be surprised if at the time the structures are built, we are at capacity then. But what I am hoping as the court administrator is that we will continue to look at our justice system, continue to work with our other justice stakeholders to see how we can modernize and bring about broad-scale efficiencies in our justice system to not only reduce the amount of people that are actually coming to court and using our services, but also to ensure that we have mechanisms whereby the cases can move through quickly, and there are alternatives that do not bring the cases to court. And as I said, the tools that we have now are mediation, and that is, we are in the very early stages of mediation in the Cayman Islands, but that is certainly a viable alternative whereby parties can opt to use that route, or the court can direct them to consider it. Whilst we cannot require parties to use an alternative system like ADR, we certainly can inform them and educate them of the process, and at least encourage them to give it a try, and hopefully they will either fully resolve the issues, the legal issues in that environment, or by the time they come back to court, they are reduced. Sorry.
I have a couple of questions.
Sure.
You all tabled a report last Friday, Cayman Islands Judicial and Judicial Administration Report 2016-2017. All of the matters that come before the court in 2017 on the summary court are below what came to the courts in 2008. Traffic court is down by 50%. So what is the justification? Is the 13 courtrooms being driven by data such as this, or what are they being driven by?
The number of courtrooms that we are getting through the proposal is driven by money. It is what the actual plant can be built. We need more.
If you had more money, you are suggesting that we would need more than 13 courtrooms to deal with reducing cases than what we have now?
I'll have to go to see what the original options analysis was for over a 25-year period, but the original proposal was for a 25-year lifespan for the courts. So the original one would have been more than 13 for over a 25-year period. I mean, what we largely did is we took the criteria of the proposal that was made when the court was to be built down by Halfway Pond, because we actually had plans for that and a lot of work had gone into that. And I believe at the time that was identified at about probably $20 million, but that was a long time ago. And so we have not really scaled it up beyond that because of the financial constraints. And we are at 7. What has been proposed is no more than 10 in the new structure, and we use the existing 3 that we will have and will have shortly. In terms of the reduction in numbers is not a sole indicator of efficiency. What this court is finding, and our measurement tools moving forward will help that. But some cases are taking longer to move through the courts, and not just in the summary court. They're taking years sometimes to move through in the financial courts, the family courts, and to some degree in the criminal courts. So criminal courts, there's a priority to push them through, but when you're dealing with cases whereby it is party-driven, and in family cases where they don't have an attorney, they're unrepresented, they do not agree, they might leave the jurisdiction, and then the cases go dormant. In financial cases, when you're dealing with monies up to $100 million, these cases on average can be 3 years in the courts, just in the Grand Court, and then they're appealed to different courts, and we're using the same facilities, and then they come back to the Grand Court in some of the hearings. And I don't intend to go into the details of it because that's not appropriate here, but the number itself is not indicative of use or lack of use. It's about the types of hearings that are coming through the courts globally and how that is happening. And actually, when we attend court conferences, this is something that courts are starting to speak about. How do we start looking at this? Because this is a new dynamic that is happening in court systems.
Thank you, Mr. Chairman. Just looking at just pure numbers now, and the accountant and me have just come out. At present, you say you have 7 courtrooms. 7 courtrooms at an average of 6 hours a day, 5 days a week, 52 weeks out of the year, is 10,920 hours of court time available. Looking at the statistics on the court between 2010 and 2018, but just focusing on 2018, the total amount of cases that went before the Court of Appeal, the Grand Court, the Summer Court, and the Specialty Court was 10,668. The total amount that are traffic related is actually 7,451, or 70%. And I think this is really where we have an issue, where the traffic issue, and that's why we welcome the fact that you guys are looking at the traffic issue, where 70% of the issues going before the court being court time. So if you take 10,920 hours of court time available, and you have 10,668 cases, you're basically trying to say 1 hour for each case, and we know that's not going to happen because the criminal courses go on for weeks and so forth. But then we have 70% of it sitting in traffic. The real question is then, once we're able to fix the issue of all of these traffic issues coming for the courts, then the next question is then what will be the true need in terms of spacing for the court? Because then you will have roughly 3,000 and something cases and roughly 11,000 hours worth of court. I mean, these are the kind of analysis that we're looking at to say, well, what makes sense from what don't make sense and so forth. But I mean, if we continue with the high amount of cases come to the court, stuff that we don't believe should come to the court, stuff in other countries that don't even go to the courts, then what's the next step?
Thank you, Mr. Saunders. The analysis that we'll have to take forward is what is going on in the full court activity and not just the summary court. Certainly in the summary court, if the traffic component was either entirely or significantly taken out of the court system, then that division itself will have to look and see where does it dedicate its time and how does it use its newly available court time more efficiently and to process other cases through the court. So I will give an example of this. In the summary court itself, there are many subdivisions of summary court. There is the general civil small claims. There are maintenance cases that are quite voluminous also. There are the drug court that is held once a week. There is a newly formed mental health court because the court has recognized that some of the repeat defendants that are coming before it are actually suffering from mental health concerns. And so therefore the court is moving away from, in a summary court, moving away from just dealing with the offense and the person and then pushing them forward only for them to be back 2 weeks later to try to address and help the defendant through the court system address their additional needs that to help them prevent them from coming back. And this is an interagency courts. These are rehabilitative courts, and they involve the probation department, DCFS, health services, counseling services, so that the person who comes before it, the whole person is looked at through the court process. And when the end of that process happens, for example, in the drug court, they do not leave the court with a conviction if they go through the program successfully. They leave the program clean, and they do not have a conviction recorded, which can adversely impact their life. In the mental health court, we do not have underpinning legislation, so that is not as much as a developed system, but that is certainly something the court is looking to grow and to formally develop within the summary court. Likewise, domestic violence cases, which are very urgent and can be very complex and sensitive cases. Whilst there is currently a memorandum of understanding between the DPP's office and the various government agencies with the court to fast track those cases, I wouldn't be surprised if that is something that will also be formalized in the future with the summary court. So there are different initiatives at the summary court level, I believe, that can be looked at and can be used to help move those types of cases through. And certainly the court, to a large extent, is responsive to the activities of the population. What the court does not have control of is who comes to court. That is the Director of Public Prosecution's office and the police, and perhaps they're responding to the need for law and order and justice when individuals in the society and community breach the law. The summary court also deals with child protection matters, and those are also sensitive matters for the family. And some of them are public law, whereby very serious decisions have to be made. They might seem simple, but they do have very complex human rights components to them. So I would anticipate that even with the removal of traffic, I do not believe it can be taken out 100%, but I do believe there could be vast improvements to what comes to court and at what stage. The courts are always developing because they help meet the need of what society needs in a justice system. It's not just about the crime that has been committed, certainly not at the summary court level. In the grand court, yes, but not the summary court.
Quick question. Just going back earlier, we've been working on the outline business case now for roughly 2 years. It's been batted around. The next question is then, when can we expect the outline business case to be completed? And then more importantly, when can we expect the actual business case to be completed? Because there's a lot of money being spent, a lot of money being batted around, but the financial justification for why we spend this money, for why we're doing that, still eludes us. So that is really my final question in this area. When will the OBC be completed, and when will the business case be completed?
Thank you, sir. The OBC team met in January this month to put the final nuts and bolts on the outline business case, but there is a need to modify it because the funding that was requested was not given at the level of funding requested. It was as less funding was given than what was requested. And my understanding from the various technical persons on the team is that this will impact risk in their risk assessment that they did, and certainly given the urgency that our administration is asking for the early works for the Court of Appeal and the temporary court work to be done, we are trying to navigate through the procurement strategy. A procurement strategy has been proposed, and I do believe within about a month or two, the outline business case will be available to the cabinet. But in terms of the early works itself, even starting, my role now is to get the project, work with the special project office, get the project manager, figure out the procurement in terms, in line with the procurement rules, and see how we can get these things, the money spent and the plant built for the Court of Appeal and the temporary Grand Court in this budget year by summer. Sorry. We're a bit lost, and this is important to put for the record. Mm-hmm. What the judiciary needs is what the judiciary needs. And while I do recognize that there are financial constraints, what I would suggest is that the outline business case and the business case, which gets into the nuts and bolts, actually says to the elected representatives that this is what the court system needs. And then I think after that is done, we can then see what best we can work on, what we can fix now, what we can put in now. Because it seems as if though the financial resources is driving the need, when in fact the need is the need. And then I think we put the financial resources to it. But if you're trying to put a business case or outline business case within a particular budget, it's not going to work, because that is not long-term thinking. What we need clearly, and I think this is where the frustration comes in sometimes with us and members of the public, is that we need to know what we need to have an efficient court system in this country. And then it is our job to go out and find it. Because one of the things in most constitutions that they have always been wary of is the fact that the legislative branch have always had control of the purse that is needed by the executive branch and also the judiciary. And as such, we need to make sure that the legislative branch is doing its job also, because they can stifle both the executive and the judiciary by the power of the purse. So it is important for us, at least for me, I can speak for me and other members, is that we know exactly what it is the court needs, fully, uncut, uncensored, to serve the Caymanian public, because this is one of the pillars of our democracy. Then we can decide, okay, here's what we can do now,
here's what we can do 3, 4, 5 years from now, here's what we can do 10 years. But it can't be a situation where, because you only have this amount of money, well, this is what we're going to do. That clear vision needs to be put out there. It has to be a clear vision, a clear mission, a clear what you want for the courts, and then give us the task to go and find the money. But it can't be driven by the finances.
Thank you, Mr. Saunders. Certainly, I have taken special note of that. That is the court is going to be undergoing a strategic plan this year to look at everything concerning the court and all of the ancillary justice needs that the court is involved with or participates in. My mandate from the Chief Justice is let's get this activity concluded by the end of the year, so that we know exactly what our visioning is for at least the next 5 to 10 years. With respect to the plant itself, certainly it is challenging because I came into this role midstream, and at a point where there is a struggle about what can we afford, and I really don't have the answer. That information, I don't have it, and I will work with the various government agencies to get to the point where we can tie in the need with the cost, so that the government can, in the long term, make decisions and commitments for the long term for courts facilities in the Cayman Islands. I am definitely would continue to work with those people, including the Auditor General's office and the guidance given. We've not discounted at all. We can't discount what she has written because it is a legitimate concern raised by the P.A.C. But it has not been a straightforward OBC, and we're looking to get this to the end, whilst we're trying to meet some of the interim court needs with the temporary Grand Court to move the cases quickly in that court and also the Court of Appeal.
Thank you very much. I think you have just, in essence, now laid out for us a framework, because what you would expect in normal business practice is first is a strategic plan done and completed. Then there are several business cases that would be done or completed to achieve the overall strategic direction. But I think that is one of the things that has to be concrete down, is in terms of what the court ultimately is going to look like, and then the business cases developed along the way to achieve certain parts of that vision, that strategic plan. And I think that is ultimately where we're going around in circles, because we have gone up, we have bought a building for 10 million, but the business case to justify it isn't there. You know what I mean? So it's kind of, we know we need space, but the question is, what kind of space do we need? Like you said, you know something needs to be done. The question is, what needs to be done? And for us, it's a matter of getting that long-term planning in and getting that culture in, because a lot of issues for us is still cultural that we have to change. Some has to change on the lawyer side, some has to change in terms of the expectation from society and everything else. But that is ultimately what it is that we're looking for, is this is where the court is going. The plans are then developed to get the court to this goal, and then we go and refund it. And I think that should be the normal progression, as opposed to, so.
Mr. Chairman, through you, certainly along the lines of the questions presently on the floor, but using the Auditor General's report specifically to detail what my concerns are. It certainly seems, as the member from Waddingtown West just mentioned, that as it relates to the court building and the new structure, we seem to have put the cart before the horse in determining the justification for this new purpose-built facility. But I have specific questions specific to the report as it relates to the court building itself. Paragraphs 61 to 66, found on pages 24 through 25, report that the existing court building is not fit for purpose. It goes on to state that the design of both the individual courtrooms and the building itself is inadequate, For example, there are limited facilities for protecting and supporting vulnerable witnesses and victims. Paragraph 66 goes on to highlight that the multi-agency nature of the criminal justice system means that it is important that the new court buildings meet the needs of all the justice organizations involved in processing cases through the courts. However, the Auditor General's office noted that none of the stakeholders involved in these various justice organizations that utilize the courts had been consulted on the initial proposals or been given the opportunity to discuss their requirements for the new courts with regard to the new planned design. My question, therefore, Mr. Chairman, through you is, with backlogs and delays cited as reasons for the need of a purpose-built structure, what assurances can the witness give this committee that the new structure will in fact meet the needs presently absent in the court system and also lend itself to reducing the backlog in cases which I think as of the 13th, as of March 2019, were I think it was over 1,300 cases presently yet to be heard by the courts.
Thank you, Mr. Chairman, through you. With respect to the stakeholders' inability or to give feedback, this was raised in the Auditor General's inquiry, and I did indicate at the time that I was of the belief that there was consultation, but it happened before my time, and I admitted that I could not find any documents on my end. I did make inquiries with the stakeholders in the OBC team, and I did not get any firm feedback, except that they believe that there was consultation. But since that time, and since the publication of the report, I was able to get information from the Canadian firm, the architecture firm that is part of the OBC, that was involved in the activities from 2015, that at the initial stages, consultation was in fact done with stakeholders, and they have now been able to provide me with the feedback reports. And I can confirm that, and I have a copy for the Auditor General because she did not have this and I was not in a position to give, but I can confirm that there was a questionnaire issued February 2016, and that's this internal staff of the Judicial Civil Registry was consulted, and very extensive feedback was given based on the questionnaire. Also, that there was a preliminary response from the Office of the Director of Public Prosecution given on February 25th, 2016, where they spoke specifically about the vulnerable witness rooms, separate waiting area for prosecution witnesses, etc. There was feedback provided by the Department of Children and Family Services at the time. There was also feedback given by the attorneys using the Financial Services Division. There was feedback also given by the Prison Department. There was also feedback given by the Attorney General's Chambers. There was feedback given by other internal departments, the Court Reporters Division, family law attorneys, our Accounts Department. So it does appear that perhaps with the progression of time, the agencies or some of their representatives might have forgotten, or they may not be the same person. But the architectural firm did provide me with the actual surveys and and the feedback given at the time, and the architect did inform me that all of the plans that were delivered in 2016, the options analysis and any plans progressing from that have taken on board those feedback. Now I can say, Mr. Harris, that it is true that the main court building, before Scotia was, the old Scotia building was purchased, the court did not have a lot of these facilities and we simply could not accommodate them. But in the absence of the renovations taking place now, we have not kept the building idle. So we have tried to fix it and clean it with the existing infrastructure, and some of the staff have moved into better physical conditions. We are able to provide more appropriate spaces for some of our judiciary. And we actually, I think last year, actually had a dedicated space for vulnerable witnesses, which was beginning to be used. And we're actually near the end now of opening up the third floor to be used for attorney rooms, general prosecution witnesses, defense witnesses. I'm hoping to bring that online on Monday because it is ready. So whilst we do appreciate that there will be renovations to this building over time and that there will be expansion, that we are in a position, at least for now, until all of the work start, to provide these much needed services to our stakeholders. And we are in the process of writing the memo to let them know they're available and the rooms are ready.
Mr. Chairman, just through that, first of all, I want to thank the witness for providing that stakeholder consultation and for agreeing to provide the same to the Auditor General's office. I'm sure they'll find that useful information for the purposes of any follow-ups or otherwise. However, you stipulated that this was a consultation initiated in the years 2015 and specifically 2016. Presumably, a lot of the persons that lead those justice organizations over a period of 4 or 5 years and who may have given consultation may have moved on and been replaced by other persons. Has there been any updated consultation, perhaps with new leaders of these justice organizations coming in, or any updated consultations regarding the needs of these justice organizations, which may have changed, plus or minus, over the last 4 or 5 years? Obviously, that too will have an impact on the efficiency this new purpose-built structure will have in managing the court's time. Surely we want to ensure that all of the users of the courts have their needs met and that their needs are indeed current as opposed to perhaps 5 or 6 years old. I wonder if you can inform this committee if there's been any update on those consultations, save what was shared in 2016.
Thank you, Mr. Harris. No formal surveying has been done to update the information at this time. We have based it for the purposes of the OBC, what has been provided. What I can say is that there are engagements in different connected areas with other stakeholders, some of the stakeholders. So for example, with the prison department, which is a major stakeholder, with the question of the plans itself, now that we actually have something that looks like what we will present to the OBC with this version, I have actually invited the Director of Prisons to review it with me, and I have provided the Commissioner of Police with the plans for his review and for continuous consultation, and particularly with respect to what I would describe as our 2020 initiative as a interagencies on looking at court security in the round, not just what we need now in terms of the existing plans, but in terms of these new proposals, even though they are high-level designs, it is important that we get their input because their agencies are the most impacted because the prison, for example, is the entity responsible for transporting prisoners and for taking prisoners away from the court to the prison, and certainly they will have on the ground the biggest external agency facility in any new court building, and certainly the police services, because they do have general security oversight for the courts. The fact that we now have the old Scotia building, the fact that there is a request to put temporary courts in there and a permanent court of appeal, that the commissioner has been invited as part of our ongoing court and judicial security engagement to look at this specifically. They have advised us that they do not have the internal expertise to advise us, so we are in active negotiations with them to discuss with the a branch of the Toronto Police Service that provides court protection for the Toronto courts to engage with us to give some technical and expert advice on the kind of security measures the courts should put in place now, but also what we should prepare for in our court design moving forward. So we have started it, but with those agencies first, and we will be reaching out to the DPP and other ones for anything beyond what they have given before.
Mr. Chairman, through you, I'm not going to argue whether there is a need for new court space or otherwise. Certainly that is for the witnesses to determine and convince the respective bodies. But what is clear this morning is that the desire for a new building has superseded the desire to ensure that the proper processes, the value for money, the outline business case, followed by the strategic business case, followed by who will use this court's system to ensure whether or not the differing needs of the justice organizations will be met by this new building. None of these essential questions have in fact been asked, but yet we hear time and time again that the courts need a new building. As it relates to the people who will work in that building, we also see gaps from the Auditor General's report that will give this committee, and by and large the people of the Cayman Islands, the taxpayers who will pay for this new building, whether or not the efficiencies desired will in fact be achieved by the completion of this new building. I note specifically, Mr. Chairman, through you, paragraphs 67 to 69, contained on pages 23 to 27, that states that at the end of 2018, the Judicial Administration had 74 staff. However, the lack of staff was consistently raised as an issue affecting the efficient operation of the summary courts. However, the Auditor General's report found that Judicial Administration had not done any workforce planning to determine how many staff it needs and with what skills that staff will need in order to efficiently deliver its objectives and meet future demand. For example, it is not clear what impact creating additional courtrooms will have on staffing requirements. Will we need more paralegals to allow senior managers to focus on more strategic issues? Or will we need more magistrates to deal with the backlog and caseload? My question, therefore, Mr. Chairman, through you to the witness, is can you inform this committee what workforce plan or workforce planning has been conducted in order to ensure that the intended outcome, both of the development of a purpose-built facility as well as the sufficient staffing needs are met to ensure that the delivery of justice in the Cayman Islands is delivered in a timely and efficient manner.
Thank you, Mr. Chairman, through you. I can confirm at this time that no workforce plan has started. And this is not an excuse, Mr. Harris. This is simply a fact. As the Chief Officer and Court Administrator, it is something that I am keen, because I am aware of the expansion that is likely to happen, whether or not we have new facilities, the sheer volume of cases that are coming in, and certainly what our HR teams and our department heads are telling me on the ground about staff stress and being overworked. Until I can get that done, I have taken the approach of encouraging managers to bring about changes in their business process, to bring about more efficiencies, to see how they can do their jobs better. Training of staff to ensure that they actually understand what they're doing and they're not making mistakes and therefore having to do things over. That is something that is being incrementally delivered across the organization. I have engaged with the Chief HR Officer. I have had the intention and the desire to engage in more strategic HR planning in the organization. It just simply has not happened. But certainly it continues to be a front burner priority for me in terms of administration, because I am keenly aware that we do need to understand to what extent our staffing is meeting the business need, and also the skills of the staff to also meet the business need. That is another demand that I believe is urgent. Because as we improve our services, perhaps the unintended consequence is that more is demanded of us. And so therefore, I do not wish to have our staff in a position where they do not feel they can deliver, but certainly to make them have the confidence that they're able and they understand their roles. And we are journeying through that incrementally. It will be a feature. Training will continue to be a feature of my budget proposals on an annual basis, because there is a lot of training that needs to take place. And I believe this is across the wider civil service too, through the world-class civil service in developing our professionalism. In terms of the workforce planning, I do note that the Auditor General conducted an audit in that respect. And whilst I will lead that initiative from where I sit, I continue to engage with the portfolio of the civil service to also provide me with staff that can assist me at the strategic level. At present, I have no deputies. I cannot rely on the clerk of court because her role is in law, not in administration. So we are working through these administrative obstacles, and I believe we will be confident to bring these online sooner rather than later.
Mr. Chairman, certainly through you, I want to thank the witness for acknowledging the shortcomings rather than trying to defend those shortcomings, as we oftentimes hear in this committee. So I think it's very refreshing, and I thank you very much for it. And I just want to certainly underpin the importance of workforce planning, whether it be the judiciary or otherwise. Certainly there's an education component. You know more than I do that there are hundreds of students throughout the education system, perhaps in different stages. We acknowledge they all can't be lawyers, but they all perhaps may aspire to be. But certainly workforce planning in my mind is important, particularly for those students, in terms of guiding them as to what the needs are and therefore what they should otherwise prioritize in their studies. Again, not everyone can be a lawyer, But if there is a defined need for more paralegals, then that may be an avenue. If there's a defined need for more clerks, then that may be an avenue. But this information is essential, and certainly from my standpoint, it is those Caymanians in the education system, both local and abroad, that this sort of plan would cater towards. So I look forward to the development of that workforce planning, and I thank you very much for your honesty.
With the chairman's permission, may I follow? It's a very positive message. We do have 2 staff members who are undergoing quite extensive paralegal studies. One who's almost finished, and we hope that he will be able to contribute more and at a higher level in our criminal division. And we do have one of our personal assistants to a judge who works in a quite complex financial area, and we are looking to support her in performing paralegal duties and independent decision making in supporting our FSD division. And certain realities are now coming to light that I am very, very encouraged for, and I'm very positive. I also wish to say that the court does have a very robust intern program. Traditionally, we used to bring the SciFEC students to see what's happening in the courts and to participate in our court-martial program. This is where they wanted to go. It seems to attract a lot of them. But also the UCCI students, we have a number of them that come at summer. We actually keep some of them on for the entire year, like a year's internship, and to help them develop skills and to be exposed to court processes. And I have to say, they are doing brilliant work. For those of you who were present at the Grand Court opening, we just launched our online platform whereby all of our public registers for the past 25 years are now digital and accessible to the public. And I will say that is largely through their efforts in scanning and entering the metadata and vetting that we were able to bring this online. And we are so thankful for their diligence and their dedication. And the organization really looks forward to continuing to onboard these type of young Caymanians and students, because they may have opportunities and become our future staff. And we have experienced that a lot of people who actually come and work with us through these internship programs either apply for jobs or and get them. They are in best place to actually come in entry positions and develop there. So sorry for going off at a tangent, but I thought it was noteworthy for the record.
Mr. Chairman, through you, those 2 people that you talked about that are in training, are they Caymanians?
Yes, sir, they're Caymanians.
Thank you, Mr. Chairman. Earlier on when I spoke, I preempted my question by an example. My learned friend thought it was political. It was not political. My question still remains the same. I gave you an example of how these things affects the lives of people. Will all of this that you're asking for alleviate or get rid of these type of problems?
Thank you, Mr. Bush. Efficiency in the justice system is evident in the Auditor General's report. Everybody has a part to play. Anyone who is engaged in the justice system has a part to play in the efficiency of it. I can state hand over heart that as long as I am there, I will do what is within my abilities to move the process forward and to help close those gaps and to work with our other agencies. I do believe that we have reached a juncture, however, where we need to have greater synergies. And I do agree with the Auditor General's observations that there are still opportunities that are not being taken between the entities to close those gaps. One of the observations she made was that the Criminal Justice Board may not be operating as intended, in the sense that the persons who are attending on behalf of other agencies may not be at the level where real decision making can take place. And that is certainly something from the administration point of view we will consult with the Chief Magistrate and discuss, perhaps be the liaison or mediator with the other entities to see how we can respond to this observation in the report. So to that extent, yes. Yes, so thank you so much.
I have a couple of global questions. Y'all finished? Okay, I have a couple of global questions and try to bring this back in focus. Can you explain to this committee how administrative policies, procedures, changes, or improvements are made in the court system?
Thank you, Mr. Miller. I would just state to put in context, there are two types of policies and rules. One is judicial-led, and the others are administrative-led.
Not interested in the judicial rules.
Right.
I'm interested in how administrative changes and procedures and rules are developed.
I say this in the context that a lot of what the administration does is driven by judicial rules, because we respond to the processes of the court. In terms of bringing about internal efficiencies, that is possible, for example, in some areas without the need to consult with the judiciary. And our organization would actually consult with experts. I'll give an example. We have a financial department. It handles all of the money that's coming into the court and that's going into the court, and how those monies are paid to people and how it affects clients. So one of the things I did is I brought someone in who was capable to say to me, what is it that we're doing? What is it we are not doing? What are the risks? What is absent? What do we need to do? And I work with them. I have a report, and I'm working with the Chief Financial Officer to address those things. And they look at, they propose certain recommendations, and we are incrementally introducing those things. When it comes to the processes and the registries, which deal with the actual court files themselves, our staff are required to, most of the staff in judicial are not just traditional admin that you may find in offices. They engage one way or the other with either the court itself or they engage with the case itself. And so with respect to the court, for example, we are looking to identify, well, what is happening in this area of the court that is modern and that it can bring about efficiencies. An example of this is perhaps our court martial department and also our court reporting department. But these areas must be done in consultation with the Chief Justice. We really can't make too many changes except for how they're performing in their current roles before we consult with the Chief Justice as the head of the judiciary. From a performance base, we do training. Our HR department plays a key role, but in terms of the work that they do, it is based upon what the court requires. I don't know if so our policies are still largely driven by the direction of the court and the judiciary in many respects for our admin staff.
The reason I asked that question, and maybe you could explain the role of the Chief Justice versus the role of the court administrator.
Okay. So for the purposes of the Public Service Management Law and the Public Finance Management Law, I am the chief officer and I have those statutory responsibilities like any other chief officer. In terms of how quite a significant section of the court administration is run, I am not actually in charge of those divisions. That is run by the clerk of court. and that position is actually in charge of, for example, our court registries, any work done in the Court of Appeal, and any work done in the Financial Services Division. And the guidance from that position are rule-based, and they are developed by the Rules Committee, which the Chief Justice leads. So that is, they can make laws, but their rules, the Grand Court rules is what they're called. So any procedure that flows from those rules and the staff is to perform those procedures, they flow from the rules. Now,
Not to interrupt, but having had a rule change, does the responsibility to implement that rule change or facilitate that rule change from an administrative level then transfer to you, or does that remain with the Chief Justice as well?
So it would transfer to me to a degree. So for example, I'll give the court procedure rules that just came online for case management. In those rules, there is the identification of a new role called the Case Progression Officer. So it is now my responsibility to identify the staff who can perform this new statutory function to address the rules of court. And so I will take care of all of those administrative things. Where I believe that I do have some flexibility is that there may be within the structure the ability to do the job a bit better. To what extent it will make a significant difference, it will vary, but there are ways and means for us to do our business better and more, and in a more organized fashion. And that is something that as a senior leader, I do work with the different managers and the clerk of court to review their sections and review how they engage with their clients and to review competency of staff to ensure that when they are delivering the services within the prescribed rules, they're doing so at an optimal level. But my position cannot change the rules. If I see something that I believe could be improved upon and it requires a rule change, the Chief Justice and I will discuss it, and he will give me the steer, and usually that change has to come from the Rule Committee or some other form of legislative change. We do engage quite regularly, so the leadership in administration is a joint initiative between myself and the Chief Justice and the Clerk of Court.
And you don't see a problem with that dual role and that joint application? Because my question would be, well, who's responsible?
The Chief Justice is responsible for the judiciary and the administration of justice. The judicial administration civil servant is responsible to support the judiciary in the administration of justice.
Agreed. And that's why I was trying to find out what is the separation level, because I believe there needs to be some separation from the judicial side to the administrative side in terms of delivering and providing the support that needs to be provided through administrative activities, not judicial activities, not judicial rules, right? But I hear from you that when there's a change in a judicial rule, you don't have the authority to implement the necessary administrative changes to deliver that at maximum efficiency and effectiveness. You still have to defer back to the Chief Justice.
Thank you, Mr. Miller. I wouldn't say it's a deferral. It is a consultative approach, because I must ensure that what I am proposing meets the needs.
I understand the consultation, and I'm not arguing about the consultation. I think the consultation is there. My question is, who makes the final decision? You on administrative matters or the Chief Justice?
On purely administrative matters, it is me. On any administrative matter that touches and concerns the workings of the court, it has to be a consultative process. Well, at this point, it must be a consultative process. I give, for example, the Yeah.
Question
Must be
is, it is a consultative process or is it a negotiated position?
The dialogue is very fluid. The Chief Justice, I believe that both him and I understand each other's roles. So it's definitely a partnership and it's consultative. He provides the big picture steer and I will move forward and do it. But there are times where I will need to dialogue with him and discuss things with him to make sure that as a stakeholder or the representative of a stakeholder, I am in fact meeting their need when I make judicial changes or introduce new judicial aspects to supporting the judiciary. Thank you.
Some of my questions are driven by the management responsibility and data planning and vision, because it seems in almost all of them, in fact, some of them are very specific, consultation only with the Chief Justice. Others are consultation, the responsibilities joint, right? And the consultation, often you find a statement that the management response is that you must consult only with the Chief Justice. And I was just wondering if with the expansion of the court services and the expansion of demands, whether there is sufficient separation from the actual judicial process and the administrative process.
Thank you, Mr. Miller. Perhaps if you give me an example that was concerning to you, I can perhaps look at it and give some feedback.
The very first recommendation, judicial administration, criminal justice partners, date of implementation, chief officer to discuss with Chief Justice only, although it is related to all of these other agencies, right? Your date of implementation is set for April 2020, right? But it says chief officer to discuss with Chief Justice only and obtain his guidance on how to proceed. I of the view that the guidance and administration in terms of implementing and serving the needs of the judiciary, you should be providing the guidance to him and not the other way around.
Thank you, Mr. Miller. The subject was about establishing a performance management framework for the criminal justice system. I would perhaps say that perhaps only wasn't the right word, but certainly I would put first. Because the type of data that is collected, certainly my department will make proposals and recommendations and bring rationale as to why we believe certain types of data should be collected for the purposes of performance management. But the Chief Justice would want to have steer and input on that at the end of the day.
You keep using the word steer as opposed to a consultation input. That makes me to believe that he's making the final decision, as opposed to, and that the administration is more concerned that you are on his course as opposed to being on the course of improved effectiveness and efficiency of the administrative section. Now, quite clearly, we're not talking about the judicial role and the rules, right? Maybe I'm reading too much into the word steer, but it you know.
Well, I believe that there is about the understanding of the role of the Chief Justice. My understanding of his role is that he ultimately is responsible for the administration of justice in the country and all forms that it takes, and that the civil service provides a supportive and collaborative role in his responsibility, and we support him in that. So certainly, as the chief officer, just like a minister, the Chief Justice would perceive whatever decisions are made about performance management and use of court data as being something that he must be consulted on and he must have a say in. And because it's at the end of the day, it's about how is the judiciary going to use this data and how is judicial administration going to use this data, particularly the information that judicial administration would need that is something that there would have to be negotiations on and dialogue. But certainly the judicial administration cannot presume certain things about the needs of the judiciary without having his guidance on that in terms of performance management
I'm not questioning
framework.
whether
Yeah.
he should be involved and whether there should be guidance. But I mean, going back to the same example I was just using, under your management response, it says the chief officer would receive instructions from the Honorable Chief Justice to determine the nature and extent of the engagement. I see a different role, maybe I'm just of the administration, whose I think it is that responsibility to make sure that in developing these performance managements and other things, that is your role. Of course, he would have to be, they would appear points when he's consulted, but it should not be at his direction, and it should not be, and you shouldn't have to negotiate, because these are professional standards and performance standards we're talking about, which are international indices is linked to, right? And equally where you should not be telling him and his judges how to value evidence before them.
Well, I reviewed the ICCE's report, and I did note that when they were speaking of the standards, they did indicate that it's not, whilst these are best practice standards in the broadest sense, at the end of the day, it is up for each court to determine which standards they prioritize and to what extent they implement them. And so I do believe, even in this process, that the Chief Justice must play a leading role along with me in this process. Thank you.
Let's change the subject. You made a couple of statements that concerns me in answer to questions by other members. You say you have to rely on temporary staff. Why are you relying on temporary staff and not full-time staff?
It is, well, to some degree, it's responding to changing and emerging situations that are happening in departments. I'll give an example. In some areas, the work is more, becomes more in terms of the volume of documents that are coming in for an existing case. And the staff are like, we can't do this. And the requirement is that they have to scan the documents in the system in some of our divisions. And they're like, we can't deal with the customers and have our registry open until 3 o'clock and then perform a full scanning exercise until 5. That's only 2 hours. So certainly we are revisiting, looking at exactly what is happening on the ground in different registries, and until we can do a proper analysis, we need to respond to the concerns raised by the staff. The budget years are 2-year cycles. I do know that I can make supplemental requests. In this budget year, I have sought to get what we have assessed as the short-term staffing needs for the cycle. But I did state that my intentions are now put at risk because I do have to find quite significant funding in my budget to pay the cost of living adjustment because no dedicated funding was there. And I do believe in my budget it's about $300,000. It's not an insignificant amount. I am working with the chief officer to see how we can massage our existing budget. But there may be, at the end of the day, a decision sooner rather than later to just say, please.
You're telling me, just for my clarification, that the Ministry of Finance or the collective political directive, Cabinet made a decision to give civil servants COS, was 4.7%? 5%, but that money was not added to the budget that you requested, not knowing there was going to be a 5% increase?
As far as I'm aware, sir, yes, I don't have a line budget item for that.
Okay, that's just bad budgeting, but anyway, we'll deal with that at different levels. Getting back to, you also said that much of the information and the consultation with stakeholders was done in 2016. if the 2020 outline business case is relying on a lot of that work that was done in 2015, why is it taking so long to do?
It is because of all of the changes and delays that have happened in the process. So when I came in May 2016, the first business case was ready, and we went to, I think it was caucus in November 2016, and it was not a viable. There were no viable options in the proposal. And at that time, there were no recommendations that we could necessarily say, okay, this is the next plan of action that we take to move the process forward. Sorry.
The outline business case had no alternatives in it. It was just one thing, that's it.
No, there were 3 options
Oh,
provided, and none of them were deemed suitable or affordable at the time. And that created inherent delays. And then, crave your indulgence, sir.
I think that the other thing that you said that is holding up the OBC was the fact that, and maybe I misunderstood you, is that the OBC considerations and for their proposals are now being modified by what the court system, the people believe will be the funding available.
So,
and I think that's just happens to be inherently wrong.
so there are two factors that have affected the scope of the OBC. The first one was the unaffordability of the original options analysis, and then the delays that happened after that to understand where do we go from here. The second delay was once we were able to ascertain and discuss with caucus where we go from here, and cabinet where we go from here, then it was almost like you had to start the exercise over again, because it would have had to have been a much significantly scaled down options. At that time, because the driving information, which was in 2017, was that the stakeholders wished for the facility to remain in Georgetown. The OBC team made recommendations to look at the existing infrastructure within the Georgetown area to see if there was a viable way to expand future court facilities using these existing buildings. That resulted in a assessment of 2 buildings, not just the Old Scotia building. It was an assessment of the CIBC building, which was actually on the market at the time, and that came back by the technical persons as being not suitable because of the physical way the building was structured, and also the necessary plant work that would be required for that building. Then at another building, being the Old Scotia building, came online, and it was adjacent to court facilities. And when they assessed that, they actually did a second proposal to government regarding the viability of these 2 structures that were adjacent to the existing court, and which one would have been a suitable alternative, and in what context, because it would require the expansion to go beyond those buildings. Those buildings alone would not meet any future need. It would just support. And this is also within a context too that the intention is to move entirely out of Kirk House. So it would be, you're not necessarily getting 3, you're getting 2 with new facilities. And in the end, that is the way in which the government agreed that they preferred the Old Scotia building and the option that the whole block will be used for the new court facilities. And it was on the open market. It is not an existing building owned by the government. So certainly there were some time-sensitive factors at play as to whether or not that option would remain a viable option if the government did not purchase it.
Any more questions, Ms. Barbara?
Thank you, Mr. Chairman. Through you to the court administrator. Going back to an earlier issue with the processing of cases through summary court with regard to reducing bureaucracy. Paragraph 48 of the Auditor General's report states that there are different stages involved in processing cases through the summary court system, and a number of these could be addressed by reducing bureaucracy and making better use of IT. For example, in the initial stages of processing criminal cases, the police send information on the case to ODPP. The prosecutors advise RCIPS on the appropriate legal charges, and the police then complete the paperwork and submit it to the courts. This builds in the risk that the police could potentially make errors in the final documents that are submitted to the courts. I understand that in other jurisdictions, the prosecution service submits cases to the courts directly. Question, can the court administrator indicate why we are still manually inputting data when processing cases, and why the use of information technology is not utilized? And I have a second question after.
Thank you. The question is, why is data still being manually inputted in court cases, and why ITC is not being used? Grateful for clarification. In what sense is ITC not being used, so that I can respond to the question properly?
Well, basically, because it has to go through all of these different stages, can we use IT more efficiently as opposed to just manually processing these?
Thank you, Ms. Connolly. Yes, IT technology can be used to address these duplication or these delays in service, or to remove certain steps. At present, the current rules require that, for example, that indictments must be signed by a justice of the peace. And so our current rules do not accommodate the electronic, for example, service to the court of indictments. In other cases, the rules require the original documents to come to the court. So they would have to be amended. One of our acting judges who does prosecution cases overseas actually showed the Chief Justice how they are now being able, for the prosecution, for example, can input their case into a database, and the defense counsel can put their case into a database that's managed by their Ministry of Justice. And so therefore, everything is deposited to the court through that database. Our current IT system is not developed to do that, because it would have delayed any progression in some of the things that we wanted to perceive at this time. That was identified as a phase 2 project for the criminal division in particular. In our civil, non-criminal divisions, this facility will be available, but not in the criminal divisions, because of the way that way in which those divisions function. The parameters of the system would have to be totally different. We have observed another system whereby it is used in the UK by their courts. It allows for end-to-end paperless filings, preparation of documents, trial bundles, and paperless trials themselves. And that is something that the Chief Justice is keen to assess the viability of that working for our criminal divisions in our court. Right now, we do not have any paperless courts. We will have the electronic filing of documents, and certainly the court itself will become paperless in those divisions. But in terms of moving it to the point where the trials themselves are paperless, that is something that's going to have to require quite significant stakeholder engagement. There is an appetite for it, I would say, by the court, but that will require a whole different set of discussions with our stakeholders.
So the Amanda GEMS, the new or the updated IT system, wouldn't that also be a part of this in terms of this whole system? That wouldn't be incorporated into the case processing?
In terms of on the non-criminal side, yes, whereby all filings that come in would be electronic, and the attorneys would be able to do that from their offices. But the decision of the courts themselves and the parties themselves conducting the trial electronically is a different phase which requires our external stakeholders' input. Our decision to reduce our paper and our files is something that we have control of, and we can say we want to receive them paperless. But to advise parties and to require them to conduct the proceedings themselves paperless will require quite a bit of engagement, but also an understanding of the technology and the resources required to introduce those kinds of systems, because it will require quite a bit of financial investment and human resource investment to maintain a system of that scale and to also have it properly backed up and available for court use on demand. So it's a slightly more enlarged concept.
Thank you for that answer. Just on the out-of-court disposals, paragraphs 42 and 43 of the Auditor General's report state that police cautions were introduced in 2018 as a result of the Criminal Justice Advisor's finding in 2015 that there was no formal system for out-of-court disposals in the Cayman Islands. In the first 5 months of operation, 12 adult and 2 juvenile cautions had been administered. The use of out-of-court disposals has the potential to reduce demand across the system and reduce reoffending, and the longer-term impact will need to be evaluated. Can the court administrator say what impact the out-of-court disposals have on the courts? And also, does the court administrator have up-to-date stats on how many cautions have been administered to date?
Thank you, Ms. Conley. The statement made relates to matters that are not actually engaged or under the control of the courts. These are under the responsibility of other government entities. I presume it must be the RCIPS. There is no formal mechanism that I believe would be coming to the court to identify that an out-of-court disposal has happened. It would be something maintained by another organization. What the court could benefit from through increased interagency engagement is to understand and to perhaps have greater dialogue with those agencies on how they can perhaps support the justice system by using the tools in the toolbox that would help to keep matters out of court. And that is certainly something that, as flagged, we would put on the agenda to engage with them. And I believe this is an issue that can be adequately addressed through the Criminal Justice Board environment.
And the second question was, do you have up-to-date stats on how many cautions have been administered to date?
Thank you. No, we do not have them, and I can say we have not requested them, but based upon the observation made, perhaps this is something that we should have, if it's not just simply for the purposes of having that engagement and dialogue with our other stakeholders about how we can keep things moving in the justice system.
Okay. Thank you, Ms. Bothwell. We appreciate you taking the time to come down, and the meeting will be adjourned until 2 p.m. Thank you.
role that women have played and continue to play in creating a modern Cayman Islands is significant. This is why, when I was Minister for Culture in 2009, the government I was a part of dedicated the monument Aspiration here in Heroes Square as part of the 2009 Heroes Day observances. Aspiration depicts two women, one young and one older, mounting stairs, passing and receiving the baton of opportunity, moving upwards from past to future.